I have sat on this bench for 39 years. I have faced down murderers, con artists, corrupt officials, and every variety of human arrogance this city has ever produced. I have never once, in those 39 years, lost my composure on the bench. I have never once allowed anyone to make me forget who I am and what this courtroom represents. But on a Thursday morning in October, a woman sat down in my courtroom, looked me directly in the face, and told me I was replaceable. She said it calmly. She said it the way someone states a fact they consider obvious. And in the 30 seconds that followed, she learned something that nobody in her 44 years of living had ever taught her. My name is Judge Judy Sheindlin. This is the story of Diane Calloway, and this is the morning that changed everything. Diane Calloway was 44 years old. She arrived in my courtroom that Thursday wearing a charcoal pantsuit that had clearly been tailored specifically for her body, a single strand of pearls, and the particular expression of someone who has spent so long being deferred to that the muscles required for genuine humility have simply atrophied from disuse. Her husband was Robert Calloway, Calloway Enterprises, commercial real estate, private equity, and a hospitality division that owned 43 hotels across 11 countries. Forbes had estimated Robert Calloway's net worth at $6.2 billion the previous year. Diane had been his wife for 19 years. She wore that association like armor. She had not come alone. Behind her walked a legal team of 3 attorneys, all from the same firm, all wearing variations of the same expensive suit. The lead attorney was a woman named Patricia Voss, who had the practiced stillness of someone who had spent a career managing situations that should never have gotten this far. Patricia Voss looked at her client the way a bomb disposal expert looks at a device they are not entirely sure they can defuse. I watched all of this from the bench. I watched Diane settle into her chair with the unhurried ease of someone sitting down at a restaurant where she had a reservation. I watched her glance around the courtroom with a mild expression of distaste, the way someone looks at a hotel room that is beneath their usual standard. I watched her open a small leather notebook and click a pen. She was taking notes. In my courtroom. Before a single word had been spoken, she was already preparing her version of events. The case in front of me had been building for 4 months. The complainant was a woman named Sophia Reyes, 31 years old, a licensed interior designer who had been hired by Diane Calloway 14 months earlier to redesign the primary residence, a 17,000 square foot property in the most expensive zip code in the state. Sophia had completed the work. Every room, every detail, every specification that Diane had requested, revised, re-requested, and revised again across 11 months of working relationship. Sophia had delivered a finished product that 3 independent assessors had described as exceptional. She had submitted her final invoice for $237,000 in fees and materials. Diane Calloway had paid $40,000 of it. Then she had stopped returning calls. Then her assistant had sent an email stating that Mrs. Calloway considered the remaining balance to be in dispute due to unsatisfactory workmanship. Then her attorneys had sent a letter suggesting Sophia had breached her contract in 17 specific ways, none of which had been mentioned during the 11 months of the project. None of which had been raised when Diane had hosted a dinner party in the completed residence and told 12 guests it was the most beautiful home she had ever lived in. Sophia had a recording of that. She had not known she would need it. She had it anyway. Sophia Reyes was sitting in the 3rd row of the gallery. She was wearing a navy blazer and dark trousers, the careful, professional outfit of someone who had thought hard about how to present themselves. She had dark circles under her eyes that no amount of careful preparation could fully conceal. She had been fighting this case for 4 months. She had spent money she did not have on legal representation to recover money she had already earned. She had lost 2 other clients during this period because the stress and the time and the weight of it had made it impossible to take on new work properly. She was 31 years old, and she had built her business from nothing, with 11 years of work and talent and the kind of relentless professionalism that does not come from having a safety net. Diane Calloway had decided, for reasons that would become clear in this courtroom, that $237,000 was something Sophia Reyes could simply be made to forget. I opened the file. Diane Calloway, You are the defendant in a civil claim brought by Sofia Reyes for unpaid professional fees in the amount of $197,000, representing the balance owed following partial payment. Do you understand the nature of the claim against you? Patricia Voss began to respond. Diane put her hand up, stopping her own attorney. I will answer, she said. She looked at me with the calm of someone who has never lost anything they truly wanted. She said, I understand the claim. I simply don't agree that it has merit. Ms. Reyes did not fulfill the terms of our agreement, and I will not pay for work that was not completed to standard. I looked at the file. Ms. Calloway, the project was completed 11 months ago. You hosted a dinner party in the completed residence approximately 3 weeks after final handover. Do you recall that evening? Diane's expression remained perfectly neutral. I recall the evening, yes. I said it looked beautiful because I was being a gracious hostess. That is what a hostess does. It does not constitute a formal acceptance of the work. I looked at her for a moment. You described it to your guests as the most beautiful home you had ever lived in. Is that consistent with a property you considered to be substandard? Patricia Voss interjected quickly. Your Honor, what misses? Calloway said, at a private dinner party, is not a binding legal statement. I turned to her. Counselor, I am asking your client a direct question about a recorded statement she made. I would like her to answer it. Diane looked at me. She said, people say things socially that are not meant to be taken as legal declarations. I was not conducting a formal review of Miss Reyes' work at a dinner party. I was entertaining guests. I set the file down. Miss Reyes, please stand. Sophia stood from the third row, smoothing her jacket as she rose. Sophia, I said, you recorded the dinner party comment. Can you explain how that recording exists? Sophia's voice was steady. Your Honor, I was present at the dinner at Mrs. Calloway's invitation because she wanted me available in case any guests had questions about the design choices. I had my phone with me. Mrs. Calloway began describing the work to her guests, and I quietly recorded it because I had already received signals by that point that payment might become an issue. I wanted documentation. You anticipated the dispute before it arose, I said. Yes, Your Honor, not specifically. But I had worked with clients before who changed their position on payment after work was complete. I had learned to protect myself. She said it simply, without self-pity. The way someone states a lesson that cost them something to learn. The courtroom was quiet for a moment. I let it be quiet. Diane Calloway, I said, Ms. Reyes anticipated that you might dispute payment before you had given any formal indication of doing so. Does that tell you anything? Diane's lips pressed together briefly. It tells me Ms. Reyes is litigious by nature. It does not tell me I owe her money I don't believe she earned. Her attorney made a small sound beside her. Diane ignored it. I want to go through the 17 specific complaints your attorneys listed in their letter, I said. Starting with complaint number 1. Your letter states that Ms. Reyes failed to source the primary living room furniture from the approved vendor list. Ms. Reyes, would you like to respond to that? Sophia reached into the folder she was holding. Your Honor, I have here an email dated March 14th from Mrs. Calloway's personal assistant, acting on Mrs. Calloway's direct instructions telling me that the primary living room furniture should be sourced from a different supplier because Mrs. Calloway had changed her preference. I sourced from the supplier Mrs. Calloway specified. I have the email, the purchase orders, and the delivery confirmations. I turned to Diane. Your own assistant sent that instruction. Diane's expression did not change. Assistants sometimes act outside their remit. I cannot be held responsible for every email my staff sends. Her lead attorney closed his eyes very briefly. Complaint number 2, I said. Your letter states that the master bedroom color scheme deviated from the approved specifications. Ms. Reyes? Sophia pulled out another document. Mrs. Calloway approved the revised color scheme in writing on April 2nd. Here is her signature on the approval form. I have the original and 3 copies. I looked at Diane. Is that your signature? Diane glanced at the document. It may be. I sign many documents. I cannot recall every approval form. I looked at her for a long moment. You cannot recall signing an approval form for the color scheme of your own master bedroom. Her jaw tightened almost imperceptibly. Interior design involves many decisions. Not all of them are equally memorable. I set down my pen. That particular gesture in my courtroom means I am about to say something I want everyone to hear clearly. Miss Calloway, I said, we are now 2 complaints into 17, and in both cases, Miss Reyes has produced contemporaneous written documentation showing that the decisions in question were made by you or at your direct instruction. I want you to tell me now, before we go through the remaining 15, whether you expect the pattern to be different for any of them. Patricia Voss stood immediately. Your Honor, my client is prepared to address each complaint individually, and we believe the full picture will demonstrate. I held up one hand. Counselor, I asked your client a direct question. Please sit down. Diane looked at me. There was something shifting behind her eyes now. Not uncertainty, something harder, something that had decided it was done being patient. She said, I expect the pattern to demonstrate that Miss Reyes produced work that fell short of what was agreed, and that my position is entirely reasonable. I looked at her steadily. And the 2 written approvals bearing your signature? Those are not relevant, Diane said. Her tone had changed. Just slightly, just enough. The polish was still there, but underneath it, something had decided to stop performing and start pushing. They are not relevant because the overall quality of the work was not what I was promised, regardless of individual approval forms. Sophia Reyes from the 3rd row made no sound, but she reached into her jacket pocket and took out a folded tissue and held it in her hand without opening it. Just held it. I noticed that. I notice everything. I want to hear about the dinner party recording, I said. Play it for the courtroom. My clerk pressed play. The audio was clear. The background noise of a dinner party. Glasses and conversation. And then Diane Calloway's voice, warm and animated, describing the renovation to her guests. Describing the choices. Describing the vision. And then the words, clearly audible, unmistakable. This is the most beautiful home I have ever lived in. Sophia outdid herself. I could not be more pleased. The courtroom was very quiet when the recording ended. I looked at Diane. She was looking at the table in front of her. I could not be more pleased, I said. Those were your words. 14 months ago, you could not be more pleased. Today, you are here telling me the work fell short of what was agreed. Diane looked up. Her expression had settled into something I recognized. It was the expression of someone who has decided that the best remaining strategy is to simply refuse to be moved. She said, I changed my mind upon further reflection. That is my right. You changed your mind, I said slowly. About work you had already accepted, already lived in for nearly a year, already publicly praised. You changed your mind and decided that rather than simply choosing not to hire Miss Reyes again, you would withhold $197,000 that she had already earned. That is a characterization I reject, Diane said. Her voice had gone completely flat. It is a business decision. Miss Reyes's work did not meet my standards, and I am not obligated to pay for work that does not meet my standards. She paused. And frankly, Your Honor, with respect, this entire proceeding has been a waste of my morning. I expected this to be resolved at a much lower level. I did not expect to be sitting here being cross-examined over interior design decisions. The gallery had gone very still. Patricia Voss had stopped writing. Even the court reporter seemed to slow slightly. I looked at Diane Calloway. I said, Miss Calloway, let me make sure I understand your position. You hired Miss Reyes. You approved her work at every stage in writing. You accepted delivery of the completed project. You praised it publicly. You paid $40,000 of $237,000 owed. And now you are telling me that this proceeding is a waste of your morning. Diane met my gaze. She said, I am telling you that I have more important things to do than sit in a courtroom arguing about throw pillows and paint colors. Her attorney put his hand on her arm. She moved her arm away. And I am telling you that judges at this level are not generally the ones I would expect to be handling matters of this complexity. No offense intended. No offense intended. I set my pen down again. The courtroom was completely silent. I let the silence sit for 4 full seconds. Then I said, Miss Calloway, are you suggesting that this court is beneath the complexity of your case? She looked at me. Something had fully surfaced now. Whatever had been underneath the performance all morning had come all the way up. She said it clearly, without hesitation, without dropping her gaze. She said, "I am suggesting that people in your position are generally administrative in nature. Decisions of this magnitude are usually handled at a higher level." She paused. "Judges like yourself are, frankly, replaceable. There are many of you." I said it with no offense intended, and I mean that sincerely. The gallery reacted. Not loudly, a kind of collective sharp intake that moved through the room like a wave. Patricia Voss put both hands flat on the table in front of her. Her co-counsel looked at the ceiling. Sophia Reyes unfolded her tissue slowly in her lap. I did not react immediately. I looked at Diane Calloway for a long moment. I looked at her the way I have looked at 39 years' worth of defendants who have made the mistake of confusing this bench with an obstacle rather than understanding it. Is the last thing standing between them and the full weight of what they have done. Then I stood up. I want you to understand what that means in my courtroom. When I stand up from this bench, the room changes, the temperature changes, the air changes. Every person who has spent more than 5 minutes in this building knows what it means when Judge Judy Sheindlin stands up. It means we have arrived at the part of the morning that will be remembered. Diane Calloway looked up at me. And for the first time since she had walked through my doors, the certainty in her face developed a crack. Just one, but I saw it. I said, "Diane Calloway, I want to tell you something, and I want you to listen carefully, because I am only going to say it once. I have been on this bench for 39 years. I was here before you knew this courthouse existed. I will be here, or someone exactly like me with exactly the same commitment to this work long after you have been forgotten. So let us be very clear about who is replaceable in this room." The crack in her expression widened. Her lips parted slightly. She had not expected that. People like Diane Calloway are so rarely spoken to directly that the experience of it is almost physically disorienting. I continued. "You hired Sophia Reyes. You directed her work at every stage. You approved her decisions in writing. You accepted her completed work. You praised it to 12 dinner guests in your own home. You paid her $40,000 out of $237,000 owed, and then you instructed your attorneys to manufacture 17 complaints, not one of which is supported by the documentary evidence in this file. And then you sat in my courtroom this morning and called this proceeding a waste of your morning, and suggested that I am an administrative functionary who should not be handling your case." Diane opened her mouth. I held up one hand and she closed it. "Let me tell you what I see when I look at this case," I said. "I see a woman who has spent so long surrounded by people who tell her yes, that she has completely lost the ability to understand what accountability means. I see a woman who looked at 11 months of professional work, accepted it, praised it, lived in it, and then decided that the person who produced it was someone she could simply refuse to pay because she calculated that Sophia Reyes did not have the resources to fight back effectively. Sophia Reyes did fight back. She is sitting in that third row right now, and she has produced documentation for every single one of your 17 complaints that demonstrates not one of them has any foundation, in fact. She did that while losing 2 clients and spending money she earned doing work like the work she did for you. She did that because she understood that if she didn't, you would win, and she refused to let you win." The courtroom was absolutely silent. Diane Calloway was sitting very still. The pen she had been clicking throughout the morning was resting on the table in front of her untouched. "Here is my ruling," I said. "Diane Calloway, you will pay Sophia Reyes the full outstanding balance of $197,000 within 30 days. You will also pay court costs and Miss Reyes's legal fees in full, which I am calculating at an additional $22,000 based on the documentation submitted. The total amount due is $219,000. Patricia Voss stood immediately. "Your Honor, we would request a payment schedule and the opportunity to appeal the legal fees component." I looked at her. "Counselor, your client called my courtroom a waste of her morning and suggested I was replaceable. I will not be offering a payment schedule. 30 days. Full amount. If it is not paid within 30 days, the amount will begin accruing interest at the maximum statutory rate, and I will refer the matter for enforcement proceedings. Diane Calloway stood up. Her composure had not fully broken, but it had bent in ways that were visible. Her voice was controlled, but it had lost its flatness. It had acquired something that in a less guarded person I would have called distress. You cannot simply, she started. I can, I said, and I have. Sit down, Miss Calloway, or I will add a contempt finding to this ruling. She sat down, slowly. The way someone sits when every muscle in their body is resisting it. I turned to Sophia Reyes. She was sitting with both hands in her lap, the tissue folded neatly between them. Her eyes were bright and very still. Miss Reyes, do you have anything you would like to say? Sophia stood. She straightened her jacket once. She said, Your Honor, I just want to say that I almost settled. 3 weeks ago, Mrs. Calloway's attorneys offered me $60,000 to drop the case. My own attorney told me to take it. He said the legal fees would eat up more than that if we kept going. She paused. I didn't take it because what happened to me was wrong. And I knew if I took $60,000 and walked away, she would do the same thing to someone else. Someone who didn't have a recording. Someone who didn't keep every email. Someone who couldn't fight back at all. She looked toward Diane Calloway once, briefly. Then she looked back at me. Thank you for listening, Your Honor. That is all I wanted. Someone to listen. I looked at her for a moment. I said, Miss Reyes, what you built over 11 years is worth protecting. Don't ever let anyone tell you otherwise. She nodded once, pressed her lips together, and sat down. I addressed the courtroom. Let me say something clearly for the record. What happened in this case is not unusual. It happens every day in civil courts across this country. A person with resources decides that a person without equivalent resources is someone they can simply refuse to pay. They calculate the cost of legal action against the cost of settlement, and they make a business decision to manufacture a dispute and wait for the other party to run out of money and give up. Sophia Reyes did not give up, and this court will always, without exception, be the place where that refusal to give up is rewarded. That is not a philosophy, that is a guarantee. This bench exists for exactly this purpose. Not for the people who walk in here with 3 attorneys and a leather notebook. For the people who walk in here with 11 years of work and a carefully folded tissue. I picked up my gavel. The ruling stands. Court is adjourned. Diane Calloway did not move for a moment after the gavel came down. Patricia Voss was already gathering files, already on her phone, already in damage control mode. Her co-counsel were packing briefcases with the efficient speed of people ready to be somewhere else. Diane sat in the middle of all that motion, completely still. Then she stood. She picked up her leather notebook. She did not look at Sophia Reyes. She did not look at me. She walked toward the exit with her heels clicking against the courthouse floor, each step a little less certain than the one before it. And she pushed through the courtroom doors and was gone. Sophia Reyes sat in the 3rd row for a long moment after the room began to empty. My clerk brought her a glass of water. She held it with both hands and looked at the floor and breathed. Just breathed. The way people breathe when something heavy has finally been put down. 3 weeks later, I received a call from the clerk's office. Diane Calloway had paid. Not on day 30, on day 8. The full $219,000, transferred in a single payment with no accompanying communication. No letter, no acknowledgement, just the money appearing in the account the way water fills a container, silently and completely. Sophia Reyes called my chambers when she received confirmation. She did not have much to say. She said thank you. She said she had already taken on a new client. She said the new client had been referred by one of the guests who had been at Diane Calloway's dinner party 14 months earlier. The guest had heard the recording during the case proceedings. The guest had called Sophia directly. I sat with that for a moment when Sophia told me. The same dinner party, the same 12 guests who had heard Diane call Sophia's work the most beautiful home she had ever lived in. One of those guests had remembered. One of those guests had picked up the phone and called the designer rather than the billionaire's wife. That is how the world corrects itself when the system works the way it is supposed to. 6 months after the ruling, I received a note. It came on plain white stationery in a plain white envelope. The handwriting was precise and controlled, and I recognized immediately that it had cost the writer something to produce. It said, "Your Honor, I have been advised by counsel not to communicate with you directly. I am doing so anyway because there is something I need to say that has nothing to do with legal strategy." I was wrong. Not about the design work, the writer added. And I recognized in that qualifier the last remnant of someone who had not fully arrived at where they were going, but was moving in the right direction. But about how I treated Miss Reyes, and about what I said in your courtroom. I said you were replaceable. I have been thinking about that word for 6 months. I know now that it was the most wrong thing I said in a morning full of wrong things. I am not writing to apologize for strategic reasons. I am writing because I am 44 years old, and I do not want to be the person I was in that courtroom for the rest of my life. It was not signed. It did not need to be. I read it twice. Then I put it in the desk drawer where I keep the letters that remind me why this work matters. It sits there now, beside a bookmark made by an 86-year-old woman with shaking hands and a note from a paralegal who got into law school. It sits there with all the other evidence that this bench does what it is supposed to do. That accountability, when properly applied, does not just punish. It teaches. It changes things. Sometimes it even changes people. Replaceable, she had said. 39 years. Thousands of cases. Thousands of mornings exactly like that one where someone walked in believing that this bench was something they could manage, something they could move around, something that would bend to accommodate the particular gravity of their wealth or their name or their certainty that the rules were written for other people. Not one of them was right, not a single one. That is not replaceable. That is the whole point. That has always been the whole point. And as long as I am on this bench, it always will be.